All right, we are live. I'm waiting for everybody else to trickle in. Figured I'd do my sponsor read from the jump, and today's sponsor is all of you.
Yay!
Please consider subscribing if you like this content. Throw a like and please tell a friend. It really does make a difference and it helps out a ton. So technically, you all who are watching are my sponsors, and I couldn't be happier. So thank you very much just for watching, sharing, and hanging out with us. So we have with us Nate and Elite on our Friday.
Friday!
I know that Nate is probably a little tight on time because he's got to get his track clothes on and he's got to go chase down somebody who doesn't want to be served.
Ruh-roh.
Yeah, we've been trying to serve this guy for so long. It's crazy. Let me. Well, when you're ready, I have the
Yeah. Bring it all up. Bring it all up. We discussed this before, and we could talk about that now while you're bringing it up. Okay, first, earlier this year, Chris Boozy managed to duck Jason Goodman's process server in every way possible, and it was quite colorful. I mean, he quite literally called the cops on the process server, took pictures of the process server outside of his place while he refused to be served. And I'm just like, this guy is the biggest self-owner I've ever seen. He documented the process. I mean, it would be like if, okay, what would your excuse be? I didn't get it. Nobody served me. And he, by the way, he did file later. Oh, I never got served. His lawyer actually said that. It's like, are you freaking kidding me? I would think it would be difficult to deny you were served if you have a police report. And then you go on Twitter. Oh, and it gets even better because then he tweets out parts of the lawsuit from Jason Goodman on Twitter, which, yeah, we got Joe. Joe pointed out that technically is not service that Boozy comments on the lawsuit on Twitter, but it does go a long way to saying, hey, you know you're being sued and you're trying to duck a process server, I would think.
Yes.
Yeah. The problem is you can't. The reason I made that comment is because you can't move for a default judgment until a certain time has passed from when service was properly effectuated. So that's why, yeah, he might know about it, but if he, in theory, could evade service forever, which he can't, definitely not. I mean, there's alternate forms of service, even if he doesn't want to answer his door, that the court will provide for. But the point is the clock ticking for when he has to put an answer to the complaint has not begun yet until service process has been completed. That was my point.
Does that go, though, toward a default judgment that when you show that they're not only evading it in every way possible, that they're scorning things and calling the cops and, to kind of drive the point home of, look, what do you want us to do? Do you want us to parachute into his chimney? I mean, it's not quite Christmas. Can we hire Santa Claus? How do we get a service to him?
Well, I mean, I would say that when you say move for a default judgment, so when you're suing for some certain, that's not in this case. When you're suing, there's two different ways of moving for a default judgment. At least in New York, I'm not sure in New Jersey because I don't practice here. I practice in New York, but there's such a thing as moving for a default judgment directly with the clerk of the court, as opposed to moving through the court and via motion. So you can only move, at least in this, again, this is New York. I'm not speaking to really this case. I haven't looked in because this is Ron's baby. So he knows how to do this stuff, not here in this state. Just as a general overall principle. So if you're suing for some certain, there's a breach of contract, right? You were supposed to be paid $500,000 to do something and you were never paid. So we know exactly down to the penny how much is owed. That you can go directly to the clerk and say, here's, my affidavit saying that, my affidavit's a service, my affidavit that I haven't received any answer. And accordingly, I'm looking to get default judgment. And this amount, that's a definitive amount. That's not subjective at all. And the clerk will just enter judgment for you, snap like that. I've gotten actually some phenomenally huge judgments, which were like 7-figure judgment I got once. And I just started freezing bank accounts like the next day. It's like amazing. But if it's not a sum certain, which this case certainly would fall into that, you have to move for the court to actually enter default judgment on your behalf. At that point, we start getting into things like what you're talking about there as far as the scorn and stuff and things of that nature. Because one of the things the judge will look at is, did you actually have a good faith reason to know about it? Did you not? How much of a delay is it? How late are we? Are we like a day late? Are we 6 months late? Or 2 months late? Because that's a very big difference whether you're just a few days late or you're a few months late. There's a massive difference. But also, and at that point, so if you want to try and show that, hey, he was properly served and he did know about it. So now how would you normally can't show that the guy knew about it. And so now if Ron were to have to bring a motion, in that case, he would, and he would say, well, it was my fault, whatever. I do think that it's subjective ultimately in the eyes of the court. Every judge is different. Every human is different. But ultimately, one would think that if he is late, that the length of tolerance that a judge would have for his lateness would probably shrink considerably given his extended knowledge and his evasiveness and his public scorn. So it's possible that a judge will be a little bit harsher in this situation.
Yeah.
But I can't promise you that it would have any impact. But then that even if he was just 2 weeks late, that maybe a judge would be like much more harsh on him than they would be otherwise on someone who might have legitimately not known about it. Does that better answer? I think that better answers the question.
Yeah, very well put. I mean, from what I understand, that was your specialty, at least in the area.
Commercial litigation. I used to do this. I mean, I used to sue, a lot. I'm still involved in a few cases, a few too many. But...
Oh, Kurt, how you doing?
Hey, Kurt.
I'm doing great. I only have about 45 minutes because
no
of
worries.
a stream of my own, but I figured I'd join you guys for a while.
Why is his mouth moving after his words? I hear his words before his mouth's moving.
Lol.
He's a ventriloquist. All right. Did you pull it up, Nate?
Oh, yes. Here we go. Share screen. So this is right now. Make sure it's the redacted one.
Yes. I don't want to hear.
Oh, so this is the old one. Sorry, let me pull up.
Oh, this is a good one. Yeah. I mean, we're getting a collection now. So Nate and I were talking about this yesterday. We may have to do another Nate and Eric video going through the steps and calling it Boozy Service, the sequel. There's obviously a pattern here with this guy.
Yes. So this is the process server report. I redacted everything out of it. But again, here's the key part to it. So entity evading. So the server made several attempts at the given two-family home. A truck was in the driveway, but there was never any answer at the door. During one attempt, the server made contact with the first floor tenant who confirmed that the entity lives on the second floor, but he would never answer the door. This form does not constitute a legal due diligence affidavit. So essentially, what Boozy we see consistently from Boozy. What we see consistently from Boozy.
Okay, who is that?
That was the cat.
Oh, the cat.
Oh no, it wasn't me.
Elementary.
It was Holmes. Holmes is
Nice.
I told Eric about this before we started. I'm so sorry. Holmes is wreaking havoc over here because I have a new I decided to test out doing needle felting as a craft. And so I started to make these things, and Holmes is all about them. He wants to steal them and play with them. So he keeps coming over here and trying to get in. This box has stuff coming out of it, so I can't really close it. Anyway, like I said, havoc. Please continue. Ignore me.
It sounds like Holmes is winning.
A little bit, yeah.
Okay, and somebody has construction going on. Wow, this is quite the...
I have the construction. That's me. It's not really construction. It's actually
Sounds like a lawnmower.
Yeah, give me.
By
give
the
me
way,
a
as
sec.
long as I'm here, just an announcement for LegalBytes' brother will be on my channel tonight.
Andy!
Oh, nice.
Central
Andy,
time.
game maker.
Andy
All
the
right.
Game Maker will be on my channel 6 p.m. Central tonight. We'll be playing Andy's game Crypto Cartel. So make sure to tune in for that 6 p.m. Central, 7 p.m. Eastern. All the
Awesome.
funds.
Awesome. Yeah, maybe I can watch it and figure out how the stupid game, how the wonderful game is supposed to be played, because I have no idea. I'm supposed to do it with them. I'm like, dude, I don't even know how to play the game, and I honestly haven't yet. And he's like, well, that's the point. Okay. I don't know. All right. So we've now got, is that all you got back from the summons? We don't have the colorful tail, Nate?
No. It seems like it seems like Boozy's just been doing this whole evade service thing, and to buy time. But I'm assuming he'll eventually get a lawyer and do it. But it's remarkable that someone who's, especially this multi-million-dollar company, would be running like this. It just doesn't make any sense.
World influencer. He helped Brazil with its elections. That's what
help Brazil with its and it's weird because he's helping Brazil, which is Portuguese, and then he says his program can only operate in English. So how could he do things in other countries when he himself says his bots can't interpret other languages? So I don't know how he helped us. So
I don't know. It's shaping all of the American influence, obviously.
Yeah. Oh yeah.
Just like it does with our friend Meghan Markle.
Yeah. It was weird that last video with Meghan. I don't know. It's like a lot of people didn't realize that she had made so many false statements in that interview with Oprah. That was like kind of crazy. I hadn't realized it until Megyn Kelly said all that crap.
Well, dude, I guess her latest podcast, she's continuing. So it seems like she continuously makes questionable statements. I'll put it that way. From what I understand, and no, I haven't listened to the podcast. I have people out there like the body language guy who does, so I don't have to. And what was it? She was claiming that, talking about her mother and how her mother dropped everything and did everything for her, etc., and growing up and how hard it was. A really, a good story, except according to Vanity Fair and one of the books on her, etc., I guess she lived full time with her father. Somehow he vanished off the planet. I don't know what happened, but I guess her 10 years of him putting her through private school and her living at his house and all of that, which a few years ago she stated was very important to her formation as an actress and everything. I guess she got amnesia or something happened. It's very, very interesting. But she's a gift, Nate. I mean, if you need material, she'll keep putting out content. And it's apparently not that hard.
Boozy will keep calling attention to your videos. So
yes,
that's true,
free press.
It's funny because it's not like I want to dunk on Meghan Markle. I just thought it was just interesting after the first video. I was like, oh, this is interesting. She's saying all these things. Or is any of that stuff true? But now some of that stuff happened to be false. So it is what it is.
Well, you found one thing she said to be true, right?
Kind of true, if you want to go that way.
Well, okay, it was truth on the technicality, but leaving out the harassment claims from them. So it's sort of like, well, yeah, she did go to the department when she wasn't harassing them. She asked for something or another, according to them. All right, so has Boozy commented on that? I mean, has he moved away from your eye yet?
I think he has moved away from.
No, he hasn't. There was another one. There was another one today.
Oh yeah, this morning. Yeah.
This morning. Just this morning.
I don't understand how he feels like that's okay.
Boozy seems intent on trying to prove he doesn't have class. Every time we think he's reached the lowest ebb, he finds another way. Making fun of someone for a disability, that's good. The Roots thing, that was really, really positive. Super great moment there. Accusing Nate of being Uncle Tom, that was just super, super positivity. Love to see that level of positivity from Boozy. Really encouraging.
He's just making the world a better place. That's what he does.
Yeah.
That's what he's dedicated to.
So. Yeah.
Oh, I actually got some breaking news right now. All right.
Did he finally accept service like the man that we all know that he is?
No, he actually got an attorney. His attorney is Bellard Sapir. Here they go. Let me show you.
Oh, is this the same one? Is this the same attorney as before?
No, this is a different attorney. This attorney, let me look at some of their Google reviews. Let me share my screen.
Oh, please.
Present, share screen.
This is good timing.
Yeah.
It is.
All right.
Hi, attorney friend. Would you like to tell us how we can serve your client? That'd be helpful.
Would you like to join our lawyer screen?
Maybe. So here is the
Ballard Spar. That's a big firm.
Yeah, Ballard Spar is a big firm. Yeah, so he's got this firm, and they're saying, and they want to remove the case to federal court. So they want us to go to federal court, but they have to get diversity jurisdiction because we have to have. Oh, it's got to be a controversy over $75,000. So
I don't think that's possible because you sued him in New Jersey. He lives in New Jersey. He can't remove it.
No, you can remove it for diversity.
No, not if he lives there. He can't. You sued him in the state court in which he lives. That's an exception to diversity.
It's not just him though. It's
any defendant, isn't it not? Under the rules of federal procedure, unless I forgot something, isn't it? You can't remove if any of the defendants live in the jurisdiction in which the lawsuit was filed.
I don't know. I always thought anybody could remove because I thought diversity was just about the amount.
Sentinel. If Boss Sentinel is in another state.
Hold on, I'm going to go look at the federal rules of civil procedure. Hold on.
Yeah.
No,
I know that the judge can do it. A federal judge can remove it from federal court sua sponte. But as far as taking it from state court to federal court, I haven't looked at that it's been a minute.
Yeah. Well, you just need diversity. You need diversity, and I think
that's the claim of $75,000.
Yeah,
more than.
More than. But you're saying 75,000 even would not get you in?
No, it has to be more than 75,000. They are very sure to make sure that you know that for bar exam purposes.
Yeah,
more than 75,000.
I got caught one of those questions.
75,000 will not do the trick.
And they got me with the 75,000 or more, and I was like, yeah, that sounds good, but it was like no, more than
that's wrong.
000. Yeah.
Oh, no, that's wrong.
That's hard. That's so ticky tacky. I hate questions.
Yeah, well, welcome to the bar exam. Right?
I hate people who come up with questions like that. That's so what's wrong with you?
But the other one was there, though. The other one was there.
It's like since you knew it has to be 75,001, not 75,000. Now you're ready to be a lawyer. Like it's such a stupid, arbitrary thing to ask about.
You know what, though? Maybe it is because it's an attention to detail type of thing. Like, are you really reading the complaint and getting it down to that semantical level? I'm not sure.
I understand what you're saying when it comes to breaking down complaints, and you're correct about the importance of being of scrutinizing very carefully when you're dealing with a particular case. When you're trying to swallow volumes of knowledge for a bar exam, to try and catch you on those ticky-tacky sort of things. To me, it's not establishing this person is more prepared to be that this person imagine failing the bar on that one question, because I mean it's so wrong to me, but whatever.
Look at this. Hold on, I want to show you guys this because I just was looking at this is the first review that comes up for this law firm, which is wild. But I see why he picked them. All right, it says firm. Can you guys see this? Yeah.
Well, let it load. There we go.
Blow it up a little bit. Firm will represent anyone who will pay their outrageous fees. Even their own representatives have stated that they will look at jury's decisions, to paraphrase a famous quote, not as the beginning of the end, but merely the end of the beginning. Clearly, they don't care for the decisions of juries and have their own interpretation of justice. The legal process currently in place is obviously beneath them. Additionally, they have stated a different court warrants a different representation, particularly as so much new evidence is coming to light. Their new evidence doesn't exist. Clearly, the rules of evidence and hearsay doesn't apply to this firm. They make up theory. There is a mountain of evidence, but not support that in any substantial way. I'm thinking this may have been
Amber Heard,
a plaintiff or something. Yeah, that
I guess, but okay.
This last part is important. They are also in favor of submitting completely doctored or manipulated evidence.
Okay.
Use your common sense and avoid this firm. This is the most current review. Wow. They will not be able to provide you honest, zealous legal representation. And this person,
that's a heavy allegation to make.
Yeah, they may be defending themselves.
That's inflammatory.
Yeah,
eventually.
I mean, I will be honest, like that level of it makes me a little bit skeptical that is a real client.
That's what I'm saying.
Right.
It might be, to me, it might be a defendant, like somebody who's on the other side.
Somebody
who just was upset and mad.
Yeah. I mean,
because why would we talk? I'm sorry, I was dealing with the noise here. Why did we start talking about Ballot Spar? What happened that we started talking about them?
That Boozy's hired him.
Oh, he hired them.
Yeah, he just hired them.
I found the relevant rule. Would you be so kind as to share my screen? Yep. All right, so we're dealing with removal of civil actions. That's what we call it when we want to take it from state court to federal court. It's called removal. 28 U.S.C. 1441, Section B, removal based on diversity of citizenship.
Mm-hmm.
Section 2, a civil action otherwise removable solely on the basis of jurisdiction for diversity may not be removed if any of the parties in interest properly joined and served as defendant is a citizen of the state in which such action is brought. So that is the form exception rule. You cannot remove it to federal court because he lives in New Jersey and he was sued in New Jersey. So
we're trying to work on the service part,
nice.
though. He's trying to duck the service part of that comment.
Thus, this is your legal education for the day. I'm happy to have informed you all.
Well done.
Thank you. And by the way, Nate, on that firm, other than the second half of it, I was thinking about the first half. The whole not accepting decisions and all that. I'm like, isn't that a law firm? I mean, I would think that I want to have a firm that I can hire to say, I don't think it was judged fairly. Can you represent me for appeal? It just, that kind of doesn't make sense. And then the statement that they don't accept one jurisdiction. They say there's different opinions. It's like, yeah, that's sort of the point, I thought. But maybe I'm the non-lawyer. Maybe I'm reading so much into it.
Well, okay. I mean, as far as them, you're right, because you sort of want to. You're correct. It's not as quite as broad as you're saying. There's certain things you can argue about and certain things you can't. You can't argue about the facts that were adjudicated by the jury, like that. Mm-hmm. You can do. Those facts become locked and basically almost immutable characteristics of the case.
Yeah.
So, for example, in the Johnny Depp case, is a great example because everyone knows this case. So the fact that Amber Heard is responsible for the statements that were made in the Washington Post, that's not something that could be appealed. That's a finding of fact that the jury said these are her statements and that these statements are not. And also another fact is that the statements were untrue. So these are now become immutable facts. So someone who's looking to appeal that cannot be like, well, the jury is wrong, and that now you're gonna have a judge or an appellate court looking at it saying, let's examine whether the jury reached the right conclusion here as to whether or not the statement was a lie or could be deemed truthful. And that's not something they're allowed to look at because that's a finding of fact that has been made. That's locked away. And like I said, it's immutable. It's unchangeable forever.
Hey, good question in the chat on this. If he now has a lawyer, can you serve him through the lawyer?
They can. They can accept service.
That's exactly what we're going to do.
Yeah.
That's it. If they, but
you compel service. I don't know that you can compel service on a lawyer.
No, well, I don't think you can compel it, but they can accept it. You can. I mean, Ron can call them on the phone and say, "Hey, we've been having a hard time serving who the gentleman who says is your client. So will you accept service?" It would be a weird thing for them to say no.
Okay, Andy. Oh, soft, gentle hands, slowly peely banana.
They say they would like. No, I think. But generally, if you're represented by an attorney, they're going to accept service for you. But again, I've had situations where I've had the opposite side said, I'm not authorized to accept service. I'm like, all right, so you're going to make me hunt down your client? I'll do it. But it just is what it is.
Speaking of their client, please, can we hold him to this? He's doubling down. No. He has opinions about the upcoming election, and he is claiming that the Democrats are going to gain at least 2 seats in the Senate.
In the House.
The numbers don't support that claim.
The
numbers right now support 53. The numbers right now support this. The Republicans picking up 2 seats, if not more. So the Democrats picking up 2 seats would be a aberration. So
you'd have to say all the polls are wrong. It's going so bad for Democrats now, because I think they just peaked too early. Like remember, like last week they were peaking, but I think that now they're going on the bottom. You know, they're going down while the Republicans are just kind of just gaining. So it's crazy because I know even here in New York, Lee Zeldin, he was like 20 points behind. Now it's a toss-up race. It's crazy.
But let's be real. There's not a chance in hell that he's going to delete his account.
Oh, of course not.
No.
There's just.
I always have to show that.
You know, if you want to put your money where your mouth is, Boozy, Predict It is still legal. You can go and predict it, and you can bet money on the outcome of the Senate race. So if you're that confident that the Democrats are going to win, right now they're paying great odds. So hey, go to Predict It, and you can bet on it, and you can earn money that then you can turn over to Nate for the defamation. So hey, it's win-win.
He better be getting money from somewhere, because I mean he's already got the Jason Goodman suit ahead of time. So it's like there's a line here. Are you guys gonna have a lottery as to who owns Bot Sentinel in the end?
Lol.
I mean, good Lord.
That's a great question. Nate, what are you going to do with Bot Sentinel when you own it?
I don't know. That's far away. You give it to the people who donated the lawsuit. But yeah,
well, there's no tech there, so we could just put up a blank page and call it the tale of Bot Sentinel.
I did see that Lex Friedman did tweet like sometime recently, like maybe like yesterday or the day before, something about like the fact that he said he wanted to come up with an algorithm to like catch bots on Twitter or something. He's like, because I think it would be a challenge and it would be fun or something. And I remember thinking like, like, so like a real version of what Boozy's doing. That's interesting. So maybe you could like just give it to Lex Friedman and he would actually do something. You mean
Lex Friedman, the MIT scientist who is one of the top in the world
Who's
for
brilliant
actual artificial intelligence and machine learning, is saying that it would be a challenge for him to do. But of course, you know, he's way behind Kitchen Boozy, you know, is the world's foremost expert in the world. Super chat question. I don't know. Is this the same firm that has Amber Heard's appeal? Did they get a group discount? I'm not sure. I don't follow the law firms.
I don't know. I'm not sure who.
I would be curious if that firm represents. Let me see, Amber Heard or the what's it? They call them the Harkles. That's one of the new one.
What's that supposed to be a reference to? The Harkles?
Meghan Markle and Prince Harry.
Oh, I never heard that one.
It's just you know, it's like Benifer,
right?
Portmanteau.
Harkles is weak.
Yeah, well, it is weak, but there is
Hagen would be better even.
Well, there's a connotation to it though that essentially the majority of the name is Markle versus the Prince, and
I guess Harry is HAR and is MAR. So
right.
AR overlap there. All
right. Joe does not approve.
I'm not. Yeah, I don't approve.
Okay, so Nate, you filed a suit. When was that? Last Wednesday? No, last Friday, right?
Yeah, it was like a week ago. I think a week ago. Yeah.
Okay. And
have you tried service by boombox? Standing outside his house with a boombox, just saying the complaint in his direction.
Well, but you know what? The fact of the matter is that now, since he's represented, I think we're good, right? I don't think we have to worry about the service issue. But it's funny. It's funny because, you know, generally any legitimate person or any all these somebody comes, knocks on your door, you open your door, and you take the paperwork. This whole hiding behind under the table with the Goodman lawsuit and hiding about it. It's like, you know, I think he's got this fear. And you can see it. You know, we all see what's going on here. This doesn't seem. There's a lot of smoke here. There's a lot of smoke because it's just someone who, if your company's worth 16 million, as some of the websites have proclaimed, this is not the activity of somebody who has thousands of employees and a multi-million-dollar company, right? It's just not adding up.
No, you would probably have a lawyer on retainer for the company, and you would say, go give it to him. Or her, you know, give it to this lawyer I have on retainer. If they don't work there full time, it would be somebody that represents them for whatever contracts, etc. It'd be like, yeah, send it over there, and get served accordingly. So, that would be ideal. But Kurt, to your idea, I was talking to Nate about this yesterday. what would be fun is if you could get the process server to live stream process serving with Nate on the other end, so that way you can't say anything about, or no harassment or not. Nobody's bugging anybody. The guy would just have his iPhone on with a StreamYard session, and we could learn too, right? This is an educational opportunity to find out, how does this process serving thing go? Can we look at that? Now, what would you do normally? Is somebody there? What would you do now? I think it would be a fantastic learning experience for everyone to have a live stream of the Boozy service.
Yeah. Oh, you were right, Eric. Boozy did hire Amber Heard's attorney. What a coincidence.
Okay. Well,
look, they're hardcore winners, obviously. So.
They're hardcore. Speaking of which, Amber Heard did get offered a secondary career to help pay her legal fees.
I wonder if Amber Heard's lawyers are less expensive now than they were in the past, just out of, I wonder if their market price has been adjusted.
So wait a second. This is for Virginia. They had something to do with Bredehoft and what's it?
No, they hired them for the appeal.
The appeal. Yeah, there's still that whole fight that's going on over who's going to pay for her trial fees, right? Or the legal fees leading up to trial and including trial. And of course, she I mean, you guys saw this week, right? How she came out and said, "I'm basically homeless and I'm a vagabond,
yeah,
so I therefore don't have a domicile anywhere."
That was cute.
That's a fantastic legal argument, though. The argument.
I mean, it's
It's pretty fantastic.
I say A for creativity, right? Like, but whether it's gonna win is like a pretty big no. I think.
I don't know. It's reading through it. It sparked my because so everybody understands, because I hate when we're talking about this. I know a lot of people. I don't want to lose the audience. So there's diversity jurisdiction that Kurt was just talking about. Mm-hmm. There is a quirk in diversity jurisdiction. So diversity jurisdiction usually can work if you're a U.S. citizen suing another U.S. citizen and you're in different states,
right?
But or if you're a U.S. citizen suing a citizen from another country,
right?
That would also work for diversity. But if you have two U.S. citizens and one citizen is not domiciled in the United States, you can't sue them under diversity jurisdiction.
Yep.
And that's what Amber Heard is using, because in the complaint from the insurance company, they say this jurisdiction is proper based on diversity. And that's her claim, is like, well, you don't have diversity because I'm not domiciled within the state. So that's going to be interesting.
Somebody said, though, at the time that they covered her for the case, she was.
Well, I mean, there's a dispute. She still had a house in California, which isn't quite the same thing as being domiciled there.
Yeah.
But it's not the same thing as not being domiciled there. So we could have a fight over it.
Yeah. I mean, so the house was sold after the litigation started, both of these, which have now been put together into one case. They've been consolidated. So there's that issue. There's also the fact that the main subject matter of the case is an insurance policy that covered her in California. It was a California insurance policy. So, I mean, courts are going to look at the behavior of the parties. They're going to look at the parties, their actual like behavior that they are engaging in leading up to the litigation, rather than like what they say that they're doing. But also another point, though, is that the case law that she points to as support for her position, saying like, no, I'm basically homeless, I'm not domiciled in the United States anymore, is a case that doesn't exactly fit her situation. That was someone who had moved to Macau like 8 years before. So it doesn't fit her situation here at all.
You're right. I think you're right. I looked at their case law, but let me see. I think I might have it. I looked up. I found some other case law about it from the Supreme Court and the Third Circuit, which was like right on point, and it literally says exactly what they were saying in that brief. And that's why I think if you look at the response from what was the name? The name of the response from New York Marine. They said, well, we just don't have any evidence about it. Here's a
Can
good
somebody
article.
explain how they are involved with the lawsuit anyway? Because I never completely understood that. And remember, I'm the non-lawyer here. How do they? Yeah, and an insurance company, and I heard it was homeowners insurance or something.
Yeah, so I mean that's basically it. Like the idea is that some of her lawsuit expenses would be covered by some insurance policy that she has, which may or may not be true in the end, which is why they're suing over it. Like,
is that
saying
normal?
that we're not covered. So that's it.
Is that normal though? I mean, I'm like thinking my homeowner's insurance. I've never seen anything about if you get sued for defamation, your homeowner's insurance. It doesn't seem to make sense. That's all I'm asking.
Well, it depends on exactly your policy and stuff, but a lot of policies exclude intentional torts, which then again, in defamation, not all defamation is necessarily intentional.
Yes.
Because you have negligence.
But one with actual malice is though.
I understand, yes, but but then again, she can have some sort of special policy and stuff like that because Travelers over here seems to be like the best insurance company in the history of time. Because like, not only are we going to give you $8 million for your lawsuit, but we're going to allow you to choose your own attorneys, which is basically unheard of. Normally, when the insurance company is paying, they're the one choosing the lawyer. And the fact is, like, you have the right to your own attorneys. Like, Travelers is the best insurance company, apparently.
Well played, Mark Hudak, by the way. Subject matter jurisdiction.
Here is the case. It's Frederick v. Davis. Plaintiff and defendant were both passengers on an airplane from Philadelphia to Germany. Plaintiff alleged that during the flight, defendant, while waiting in line to use the restroom, fell on her and broke her arm. She sued defendant based on diversity jurisdiction. In the United States, the District Court of the Eastern District of Pennsylvania, plaintiff alleged that she was a citizen of Ohio and the defendant was a citizen of Pennsylvania. Defendant moved to dismiss, contending that although he was and is a United States citizen, he no longer was a citizen of Pennsylvania, but instead was domiciled in Germany. That's probably why he was flying back. After discovery on the domicile issue, because you have limited discovery to determine, that's what I think she's going to be going for, limited discovery to determine where you live. And a hearing, the district court ruled that the defendant was not domiciled in Germany and that as a result, he was stateless.
That he was domiciled in Germany.
No, I'm sorry, that he was domiciled in Germany.
Okay, yeah.
And that as a result, he was stateless and therefore could not be sued under diversity jurisdiction. And then if you will scroll down, there's even some Supreme Court cases, Third Circuit, other circuits, and the Supreme Court has also held.
But that case is different from Amber Heard's thing because she's not saying that she's domiciled in some other country. She doesn't say where she's domiciled. She just says just not here.
E. Barlow's
she has
not
to be
anywhere.
Domiciled somewhere.
Yeah. Like,
well,
her, and
much.
That's like where is her cell phone bill going to, right? Like where is that going? Like where is her like bank account out of? You know, like there are certain things that like a human being needs in today's day and age that comes from somewhere that would indicate where you're domiciled.
But that would be that's the hearing. I'm assuming you'll have, just like in the case that we just read. I'm assuming that's the hearing that they'll have, right? The hearing would be, hey, listen, you know,
domicile is an interesting
show us
issue.
Yeah, show us how you're where you're domiciled at, you know, all that type of stuff. Because I know the case was filed on like the 8th, and then she sold her house on like 10 days later. So, you know, is that enough to show that she was living there? Because remember, it's not when you move, it's when the suit was filed. That's when you're talking about. So when
should I talk a little bit about what domicile is, like sort of fundamentally, because we keep using the term?
Yeah.
Okay, so let's talk a little bit about what domicile is versus, for example, residence. So you can have multiple homes in multiple different places, for example. So there might be multiple places where you might reside, but you can only have one legal domicile. So if you're a United States citizen, for example, like let's just make it simple. You were born in the United States. Your domicile was the state in which you were born in. And then that is your domicile until you make some sort of intent to change it. The domicile is, I'm going to paraphrase the law slightly, but it's basically the place of your permanent home, the place in which you intend to return. And it doesn't matter, for example, how long you're gone from that place. So, for example, if your domicile was in Pennsylvania, just to pick a random state, and then you started living other places, even if you don't live in Pennsylvania for extended periods of time, Pennsylvania might still be your legal domicile because it's the place which you intend to harm. It's sort of your permanent home, if you like. And this also is interesting because it can get interesting, for example, if you die without a will, because we need to know what state to probate your estate in, and which would be your state of domicile. So you can get interesting issues there depending on, You know, so you might live in Texas. Maybe you lived in Texas for 10 years. Is it your place of domicile? I don't know. We could go have a fight over it. So, you know, that's a little bit between the difference between domicile and residence. So hopefully that was helpful.
Is this an unsettled part of law? Because it seems like there's a lot of variables that can make it difficult.
No, it's not. The concept isn't unsettled, just the factual determination, as always, what the facts are, right? So, it can be factually tricky.
But this issue is an interesting issue with respect to the idea of someone being domiciled somewhere and not having any place in this country of the United States, but not having any state as a domicile. Right. I've never heard of such a thing, which is what was described in the case that Nate just found. I mean, it's like, what? So where is the domicile? You're domiciled in Eastern Germany, but you're a citizen. So I guess I never heard of someone who's
there are plenty of U.S. citizens overseas.
There's expats,
there's plenty of U.S. citizens overseas who continue to vote in U.S. elections, which is fine. Because, like, again, Pennsylvania, just picking a random state for no particular reason. Like, if you go move in Germany, like, until your domicile legally changes, you can continue voting in Pennsylvania because you're still a citizen of Pennsylvania. So you have to make some active intent to change your domicile more than just moving to a place. It's again, it can be factually tricky.
So how did that case get decided then? Because if it doesn't,
presumably they're not voting in that state. Just
okay, I was going to say, I mean, if somebody did vote, would that throw their argument out the window, or
that would go? Well, that would help. That would be a factor among other factors. Right? Nothing is clean.
I would be very interested to see where Amber Heard is registered to vote.
That would help. That would go a long way to determining if she voting in the midterms. If she's voting in the midterms in some state, that would go a long way to saying she's still domiciled in that state.
Could she vote?
She is an activist.
Could she even vote?
No, because don't forget though, you had that weird. There's a weird quirk in American law when it comes to voting. Let's say if I lived in New York and I moved to France, I can still vote in New York because there'll be an absentee ballot, but I don't have to be domiciled in New York. I still can exercise my right to vote in New York. I don't have to be
without being domiciled. I'm not sure if that's true or not, but okay, I'll take your word for it.
But let's say if I move to Puerto Rico, then I can't vote in any federal election.
This is
because I'm a resident of Puerto Rico. So it's like
Puerto Rico is fun and exciting.
So it's funny because if you move to Puerto Rico, which is in the United States, you wouldn't be able to vote.
So you keep your right to vote if you move to France, but not Puerto Rico. Yes, this is true. This is welcome to U.S. law. It's fun and exciting for the whole family.
Yeah.
Okay,
that's a ramification of like the whole territory type of thing.
Yeah.
Mm-hmm.
Okay, Nate, you're gonna have to do an explainer video just on this subject because it is.
You're right. This is it's very complicated trying to break down the distinctions here, especially when you start getting to these quirkier elements like territories and things like that.
Yeah, and that's because your right to vote for federal elections is really tied to the state. So the state has so the state is actually the mechanism in which you're voting through. So if you live in Puerto Rico, that's not a state, so you don't have that right to vote.
David in chat is yelling at me. In America, you can either be a U.S. citizen or a state citizen. Well, David, I would kindly direct your attention to the 14th Amendment, which clearly says that any person is both a citizen of the United States and the state in which they reside. So that is just legally wrong. The 14th Amendment says you're wrong. I'm a citizen of both the United States and Texas at the same time. 14th Amendment for the win, yo.
One last question on that. Is it possible that Amber Heard can't even vote anyway? Because I have heard there may be a felony on her record.
I can't speak to that.
I don't know.
I mean, yeah.
I don't know. I have no idea if it's true or not. It's rumored.
But even if that, you can still have your rights restored and things of that nature. So,
but you have to actively get them restored. Last time I checked, you don't just automatically, unless a state governor signs in a law says over a certain amount of time or whatever, you don't just automatically go, okay.
But I don't have any. I just want to be fair. I don't have any evidence that she's been committed that she's in any type of situation like that. So maybe it could be true, but I just have no evidence of it. So.
But is it lawful law?
Well, I might as well take my exit at this point. I've got a stream in 7 minutes, so I'm gonna take a quick break. But it's been a lot of fun, guys.
What are you streaming about?
I'm streaming about I'm streaming about the Supreme Court case. We're doing a Supreme Court oral react. Students for Fair Admission versus Harvard. We already did Students for Fair Admission versus UNC a couple days ago, and now we're doing Students for Fair Admission versus Harvard, wherein I will teach the chat about what de jure means.
Oh,
because
yes.
there seems to have been some
de jure.
confusion.
And the
That
Gruder
was
clause.
Nice.
That was
Nice.
great.
It's Kavanaugh because he doesn't call it Gruder, he calls it Grutter. He's like Grutter, and I'm like, it's Gruder, but I don't know.
Is that really the correct pronunciation? Because I was struggling with that. Because I actually
Grutter?
had. If you send me a link, by the way, Uncivil, I'll try to pop in there for a little bit.
Yeah.
All
right.
But
Yeah, so check out my channel if you're into Supreme Court oral react. It's about 1:40, I think. So it'll take us about 2.5 hours, maybe 3 to go through the oral reaction. It'll be fun. Uncivil Law. I'll check you out on the flip side, guys.
Later, brother.
See you, man.
See you, Kurt.
He is so happy these days. Do you notice that? A total change in his demeanor. I am so happy for him. He seems to really have found his zone, and he's just a whole different animal these days, and it's amazing, wonderful thing to see. So
freedom does that.
Yeah.
The jure thing was hilarious. I don't know. Do you guys know the reference that he was making there?
No.
Okay.
No.
Okay. So this is an interesting legal thing that there's you heard the phrase de facto? You heard that?
I've heard it, yeah.
Yeah. Okay. So basically, when you talk about de facto, it's like sort of considered
like a default.
It's like not a default. De facto means like even though it's
As
not
a matter
supposed
of
to be
fact.
something, it's just that. Oh, here's what a great example. Leftists would say that, and this is I think this is the context that came up, that while it is true that the 14th Amendment says you're not allowed to discriminate, there still is tons of discrimination. So you're calling that de facto discrimination. Like the law might say one thing, but the reality is it just comes out that it's this way. You know what I'm saying? It's like it might not. You might not say here. I might not say that everyone here should like me better than any other attorney they've ever seen, but de facto it just comes out that people do. So that's.
Do you mind if I give a good example?
Please do. Please do.
An example would be like in the South, and this is one of the cases that the Supreme Court overturned, is that you had a lot of black people when they integrated a lot of the neighborhoods. You had black people moving it like for schools and stuff, and then you'd have what was called as white flight. In the case, it was called white flight, where white people would leave those neighborhoods and then go to the suburbs. So what happens is the state kind of passed a law saying that couldn't happen. And they were like, well, that's not state sponsored. The state is not saying white people has to leave. It's just a natural kind of thing that just is going on. Black people are moving in and white people are moving out. So you can't really legislate that. So that would be de facto. But now if the state said black people couldn't live in that particular part of town, now you have a different issue. So that's what Joe is talking about. In that case, because of white flight, the court said that's not illegal. White people can leave if they don't like who they're living next to.
As opposed to, let's say, de jure, which is sort of almost kind of like it's a parallel type of thing.
The day.
In reverse. De jure, no, and this is spelled Jure, which means by operation of law. So let's say, for example, a king in a country, right, where the laws are automatically when he dies, his oldest son becomes the prince would become king. Okay, he gets deposed and executed. Okay, so he gets killed. A whole mob comes in and kills him. Well, the moment he dies, his son may de jure be the king, but de facto he ain't, because they're going to chase him out. You see what I'm saying? By operation of law, he's technically the king. By operation of fact, he's not.
So de facto is reality.
Yeah,
de facto is reality, and exactly. Yes, that's a great way. That's probably the simplest way of explaining it. When Sotomayor, during this case, the SFFA versus Harvard, Students for Fair Admission, which are basically suing about the fact that Harvard and UNC, there's two different institutes that have been sort of merged together, that when they're examining applications for admissions, that they basically add points to certain races or detract points from other races. Specifically, Asians and whites are the ones who seem to be harmed, as opposed to other minorities, which seem to benefit by status of their race. And accordingly, they're saying that this is a violation of the 14th Amendment.
Right.
And when Sotomayor was questioning, who's basically very strong on the side of the schools based on her politics, so she came in and she started saying that there's still segregation. And even though there's, and let's all face the facts, you can't deny the fact that there's de jure segregation, which means by law, she really meant to say de facto. But 4 times she said de jure, meaning there's discrimination de jure, meaning that the law, let's face it, the reality is that the law says that you're allowed to discriminate. And it's just exactly not what she was trying to say. She was trying to say de facto, but she said it not once, which would be like, okay, a slip of the brain, 4 times. I mean, this Supreme Court justice, basically, she would have sounded more intelligent if she said, let's just face it, this operation de jure is clam chowder. It's like, what are you talking about?
Well, that's what I tried to say. I don't know. I'm like, of the day, de jure.
Would you like to try the law de jure?
So I came in on clam chowder.
Yes, clam chowder. Say it. Say clam chowder. Clam chowder.
Clam chowder.
Clam chowder. So,
oh my God, law of the day.
But it was just very embarrassing that we have a Supreme Court justice who basically does not know what the phrase de jure means.
Maybe she doesn't know. I mean, it kind of makes you wonder.
I don't think she does. And that's what's so sad. I mean, this is Supreme Court justice, which ironically, the whole case is about whether or not they should knock out affirmative action. And,
good. I came in at the right time of a conversation.
Affirmative
action.
Yeah. Sotomayor, whose qualifications were greatly criticized.
See, Rob.
We defer to Rob for all decisions on affirmative action.
There he goes. He's gonna just like slowly deal with that sort of thing. That's great. That was great.
No, but I agree. I actually agree with Joe a lot on this. The questions were idiotic. Half of them were. It was a long oral argument. I listened all the way through both the Harvard case as well as North Carolina case. I mean, I have no doubt the admissions, they're going to lose. Harvard's going to lose. North Carolina's going to lose. It's a matter of whether they're going to lose 6-3 or 5-4. And the questions 5-4. That were asked.
Roberts is becoming reliable.
I don't think so. I don't think so. I think it might be 6-3, at least in one of those cases.
Well, the interesting thing is this. I mean, the Grutter case is from 2003.
Yeah.
And the Grutter case basically said
25 years.
The Grutter case, which basically ruled in favor of affirmative action for applications in schools, basically said Ruth Bader Ginsburg was basically saying, this is a law we need now. If you read the decision, it reads like, in our current age, this sort of thing is still needed, but ideally, like within the next 25 years, one would expect we'd be living in a world where this is unnecessary.
So there's an expiration date.
The sunset provision.
That was O'Connor, though, who wrote that.
That was O'Connor?
Yeah, O'Connor.
Yeah, but like, and Ruth Bader Ginsburg, because it was a weird decision. I read through it very, very, very quickly, like a few days ago. It was a weird decision because there's a lot of justices who concurred in part, but also dissented in part. And because it was a lengthy decision, so you have the main decision. They say this part I agree with, this part I disagree with, this part I agree with, this part I disagree with, and it really probably required far deeper attention than I was able to provide. But the bottom line is that there was a strong recognition that the law that they were putting into place at the time, that it's given the context of our social culture today, but it really shouldn't be there forever.
It was remedial. Like, it's remedial.
Yes, and that's really the key thing. It's supposed to. We still need to fix this problem, but eventually the problem will be fixed, and we're not going to need this anymore. The problem is that these remedial provisions end up going on in theory for centuries, and it's like, and then it becomes like a very subjective thing. How much longer do we need to remediate a problem? There was terrible.
Like Tennessee Valley Authority, anyone?
Right, and the other thing is this, you can say that when it comes to the whole case with the Japanese internment, which was terrible racism, and there was remediation that was put into effect to sort of give the Japanese a leg back up after World War II in order to sort of recompense them for those wrongs that were committed against them. But in this context, they literally are talking about, and Sotomayor was saying, let's try to remediate, great grandchildren for benefits. It's like that's not remediation at that point. It's like sort of you're punishing because at the end of the day, there's a limited number of spots, and when you give a spot to one person, that means you're saying this person and take it away from another person who is more deserving. You're basically saying it's not the white race that's recompensing. It's not the Asian race, which Asians aren't responsible for. It's not that Asian you take it from. It's not someone. It's like he's like being punished on behalf of the sins of white people 150 years ago. That makes no sense.
And if you look at the historical treatment of Asian Americans, like through their time being in the United States, it hasn't exactly been rosy either. So it's like to say that they're like that they had the same exact history as like white people in the United States is being very willfully blind, I think.
But hold on. But even with that though, we do have to reconcile the fact that their experience is far different than a black experience. For instance, Plessy v. Ferguson, right?
It's not the same experience, right?
Plessy v. Ferguson, Asians were, and that wasn't the case. Asians were allowed to sit in the front and because they had white skin. So even if they were not citizens, that was a big issue.
You're right.
They were not citizens, and they got
Olympics,
this. No. Let me. No. Hold on. You can't just throw out there, well, Asians had a bad experience. And then when I bring up the counterpoint that, hey, in most of the famous cases, they showed how Asians who were not citizens had this, then that's a valid counter to the point that you're making. But I also want to say, with the whole Grutter situation, I think the context that we're leaving out is that Grutter was an answer to what's known as the Stevens anomaly. And most of you, if you guys are in law school, you know the Stevens anomaly. The Stevens anomaly, it was Justice Stevens. After the first, there was a prior case to Grutter, in which the law schools were saying, well, hey, we need an amount of black students. And that amount we're going to fix to the amount in the population. So if blacks, with 13% of the population, we had 100 students, 13 of those spots had to go to black students. That was their rule, and it was a quota. And the Supreme Court said that's racist, that's illegal, and it violates the 14th Amendment. So then Justice Stevens said, he wrote the famous Stevens anomaly. He said, well, it's a shame because the 14th Amendment was made to help black people get even with white people, but now they've actually used it to prevent that remediation. And Stevens challenged the conservatives, even O'Connor, to, okay, you're right. So when can we use it? And that's how Grutter came out, because Grutter was, okay, it's not about having a particular number, but just a philosophy. And that philosophy was using race as a factor, but not as either a controlling factor in which black versus white, we choose a black person. It was to be used as a factor to have diversity in law school. And that's what, if you look at the cases, if you look at the arguments today, law school is the only place that this was really allowed. In remedial schools, in public schools, they're not allowed to do this. So now the argument is that it's been 25 years. How long is this remediation going to go on? And on top of that, it hasn't really worked because the numbers, even though they have improved, then they're never going to be what you want them to be. So when does this stop? When do we stop looking at race as a factor? And can we use some other methods to see if we can do that? So that's kind of what's going on.
I also want to
Nate,
go ahead, Rob.
It also goes back to the level of scrutiny you apply to the law. Yes. Like there are different levels of scrutiny. So we're saying how far do we go, or when do we stop? When do we stop? It really kind of shifts. When does the level of scrutiny? When does the burden actually shift? When have you no longer satisfied that level of scrutiny by your regulation or attempt to do this? And where they lost me on this argument, where I think they lost the argument, was the factor part. The factor part in the holistic approach is a great idea in theory. In theory, when you look at, say, we're going to weigh a bunch of factors, right? But then when you boil it down to brass tacks, some person either has a factor in their favor or they don't. It is A or it is B. It is not like there's no gray area where this doesn't play a role. So if you have every single person with all things being equal, then one person has a factor that the other person cannot obtain or cannot add to their basket, you're weighing them in a different way. And then the way that Sotomayor came back on that with some of her questions, and Jackson came back with some of her questions, and Kagan did too, was to basically say, but it's a holistic approach. Well, if you're saying it's a holistic approach, then why is the factor in there in the first place? If you're saying they're not using it, why is it in there? Why do they use it?
Yes.
If you're saying that they do use it, then you're saying it matters. Like it either does.
Yeah, it does matter. I think they're saying it does matter, but it's so stupid. The whole thing is stupid. I will say that. They're saying it matters, but it matters in the way of if we get to a point where, and this is where I think Kavanaugh called them out. If it gets to a point where all other factors are the same and the only thing you got is difference is race, then does that make the difference? And we all know it does. But now what's that reason why it makes a difference? Is it because we're trying to diversify the law school and we don't and now we're looking at it? But the fact that it does make the difference, I think now puts it back to that. Now we're talking just strictly about race and not about the other qualifications in that particular sense.
Yeah, it triggers the burden shift, and that was half the debate. And it was excruciating listening to how long Kavanaugh had to ask those questions before they finally conceded it.
It was excruciating listening to Justice Kagan admit that she herself hires her own clerks based on diversity. I'm like, you have to be kidding me. You have to be. It's like it's astonishing to me how someone could become so deep in a mindset that they don't understand how ridiculous it sounds to anyone who's not trapped in that same mindset. Because I want to point something out to you. When you have affirmative action, it's not simply that it harms the races who are not beneficiaries of it. It actually harms the people who are the beneficiaries.
Yeah.
What I mean is it harms the Black students, the Latino students who get in. It harms them because at the end of the day, as long as people know that there's affirmative action, when they see what happens is if you see a Black student who's in Yale, or you see a Latino who's in Harvard or Stanford, the first thought that goes to your mind is, well, I wonder
diversity.
I wonder if they got it because of diversity,
pick.
and they're not really your typical Stanford
material.
That happened to me. No, that's exactly what happened to me. When I got in law school,
for affirmative action,
they thought I was a token hire. I mean, a token student.
Exactly. So you basically, and you could be literally if the smartest person on the planet is a young Black, smartest student on the planet, most capable student on the planet is a Black woman. No one's going to recognize her for her values, her talents, or her abilities, because everyone will start off with an assumption of token. And that's why I'm saying this affirmative action ends up hurting the vast majority who probably get in with absolutely no help from any sort of affirmative action.
There's another area it harms too.
Listen, I've done law school admissions under this stupid system. I've had the conversations with people like, yo, this guy has just had a horrible thing, but they're Black, and we need, and we want diversity. So I've been it. I've done this thing, and I agree in part, but I disagree in part in two things. Number one, the average test score for a Black or Latino student for the LSAT is at a 130. Well, for Latinos it was 138, and for Blacks it was 142. Now, the average score on the LSAT is a 150. So, for instance, most Black students, the majority of Black students, if you scored a 150 as a Black student, you were in the 80th or 70th or 80th percentile as a Black person. And the same thing as Hispanic. But that's the average score for a white student was 152. So that was like the first issue that we had, right? Because most of the way you get it is test scores and schools and your school records. The second thing is that most minority students weren't coming from really good schools. They were coming from schools which had, I don't know if you guys heard the term, grade inflation. So even though you're at a bad school, you have better grades because the grades are worth it. If you're going to a good school, then your grades are more indicative of your abilities.
I mean, if you're talking about law school admissions, law schools don't look at the undergrad that you went to. They look at your GPA and your LSAT score. That's my understanding.
No, we did. We definitely looked at it. Yes, I did admissions, and yes, we look at the law school, the undergrad you went to. Yes, we look at what school you went to, and if you were able to do it. Yes.
Nate, did you see a breakdown as to the difference of average scores between people who have green eyes and those who have brown eyes?
No, I didn't.
Why is that any different?
Why is that any different?
Breaking down between black and white. Why is that any different? Is it because of their skin color? Is it because of their pigmentation that they struggle, or is it a sociological thing where it's like, okay, in this community, where someone who's growing up living in this community, they're more likely to struggle, or maybe not community, maybe they're living in a single parent home, or maybe someone who's the child in abusive parents. Yeah. That's what I'm saying. Is everyone's trying to tie this into race, which is such a ridiculous thing.
Well, hold on.
There's so many factors. Don't tell me for a second that my kids are not completely disadvantaged compared to Sasha Obama, okay? Completely disadvantaged. That if they want to compete in any sort of playing field or whatever it is, there's no white kids who have any sort of chance compared to a kid of Clarence Thomas because they basically are coming from a place where they have wealth, they have money, and they have all these different connections that my kid doesn't have. So that's why I'm saying it's not about your race, it's not about your genealogy, it's not about what color your skin happens to come out from your parents. It's totally about your class. And it's also about it's your economics, and it's about your social upbringing. And there's so many different, and whether you had two parents, all of these play into this. And that's why I'm saying they choose to make it about race, because this is a fight that you can make forever.
I disagree with I disagree with trying to pretend that race doesn't factor into any of this, right? That's, I think, it's just you're fooling yourself, right? If green people had the same issues, then yeah, if green people or green-eyed people, that's the issue. We know you can't hide from the statistics and just pretend that they don't exist, right? You can't hide from the statistics and say, yes, there's obviously a problem. And again, I want to make it very clear. The gap on standardized tests between minorities and between whites and even Asians, that gap isn't just for the LSAT, it's for all standardized tests. You see the same gap for this, and no one knows why. No one knows why that gap exists. Now, some people say it's socioeconomic status, but that actually isn't the case, because they have actually done the studies. The University of Virginia Law School did the study in which they showed that even when you take socioeconomic factors into place, you still had this gap between the races. So you could pretend, do it for green eyes and black. But the thing is that we have the data. If you want to go do the research,
it's a cultural issue.
But they have the data. So now with that data, do we just say, well, they'll do it for people with green eyes or short thing? No, we say, okay, with this data, what does that mean? And what are we trying to accomplish? But my only problem with the way they've tried to do it is I think they all right, I can explain from my own experience. When I went to law school, I got money from every law school I applied to because I checked the box that I was black. So I essentially got free rides to like 5 law schools. And it was literally, my LSAT score was 155, extremely low, but it was extremely high as a black student. So when I got to law school, it was like, I was one of those, I got money, I was going for free, it was cool. But they had other black men who got there and who they gave scholarships to too. The majority of the black men in my law school failed out after the first semester. Now, why was that? A couple of things. They didn't have the skills. In other words, they didn't study the way, they didn't have the requisite knowledge, and they didn't have the habits of trying to be a successful student. They were there and they were giving money. And like you guys said, they were taking seats from qualified other candidates, whatever the race is, because they checked the box. That's wrong. And I think that's the problem that people were just trying to turn their heads from. And when I argued against affirmative action in this sense, because all of those students, all those black students who failed out for the first year, then they came back, and what they do for law school, if you fail out the first semester, they allow you to come back and do it again. They came back and did it again and failed out the second semester. And now you can't go to any other law school because you failed out of a law school. And if you go, you're going for full price. And that's so a lot of those students who did fail out never became lawyers. They weren't, even though some of them wanted to become lawyers, but it wasn't because of their race. It was because they were unprepared for the school. And I think if the argument here is that we should prepare black and Hispanic students for law school better to be able to compete, to be able to get on merit, that's a different argument. But I don't think that we should just that it should just be, well, we should just throw our hands up and pretend everybody is equal. I think there has to be some change. But I do think the system as it is now, if you're black, you get in, versus if you're white, you don't get in if you got to qualify black. I think that's nonsense. And I think what Joe said is right. It does hurt, and I've seen it in real action. It has hurt people. But how do you solve a problem? Because let's not forget, 50 years ago, it was, we had the black codes, right? 60 years ago, we had the Jim Crow laws, right? So, even though people say, well, it's 25 years, well, 50 years ago, we did have these things, though, right?
2.5 generations. We went through this yesterday. I mean, by the way,
the average white family with 130, who gets what, $200,000 average wealth versus the black family with $13,000. Like we can't say there's not equal. We can't just pretend everybody's equal and we're going to close our hands. We know there's some inequities. We know those inequities
always will be. There always will be. And by the way, most families lose their fortune within 2 generations too. By the way, so
what is it? The first generation.
Yes, first generation.
First generation gets it, second generation builds it, third generation squanders it.
Yes. And this is true. I mean, no, it's shown over and over and over and over. But this super chat is kind of on point, and I wanted to jump in. That's the other problem I personally see with affirmative action is it is elevating people to go to schools that they may not be qualified, and it harms them in the end, because if they went to a school, let's say, is more within their means. And I'm not trying to beat up on junior colleges. I spent some time in a junior college and everything else. I'm saying for whatever they're able to do, they can thrive and succeed. And somebody going to a state school can turn into one of the greatest lawyers in America with no problem. I think all of you would agree. You don't have to go to Harvard to be a great lawyer.
Right.
And let me give you an example of this on a lower level. So this is a debate that we're having in Virginia right now over 2 major schools, Thomas Jefferson School and the academies in Loudoun County. Fairfax County and Loudoun County both have schools, and they changed their admission program. These are STEM schools where the focus is on just higher learning. These are the best of the students, right? And the county restructured the admissions program to essentially something that was jurisdictional plus affirmative action plus different stuff. And the complaints that you're getting is that the material being covered is moving at a slower rate. They're not covering as much material as they had been in previous years. You're also getting the complaint that kids are failing. Like a lot of these kids in high school are failing, and you get a failing grade from high school, and there's no guarantee that the college you're applying to is going to adjust that for the difficulty of the high school you're in. So now you're hurting these kids and their opportunities. They might be the brightest of their school, but you're hurting them and their opportunities to go and get education. And I get that there's another side of that coin of, do we put them in a class that's more advanced to push them? But taking the approach of just selecting and using that one metric as a plus or a minus is stupid.
So bad. Yeah,
kids are so unique in themselves. Each child learns differently. I hate that we're putting that as a factor.
Yeah.
It's tough. And on top of that, it's each level is building upon skills that you have built at the prior level. So when you skip a level or you skip several levels, it's even worse, to get bumped up to where other people have gone through all of those steps. It harms the person in trying to succeed. And that can have other, obviously other psychological impacts on their self-esteem and how what kind of paths they take from there, because thinking wow, I flunked out of this and I'm not good enough for this particular school. And it can cause a lot of twists and turns in somebody's life if they take that to heart.
It's when we talk about affirmative action, we really talk about 2 arguments. One's an argument about the present. What about the people now? What's going on now? And then the other argument from the left is usually what happened before that kind of led us up to now. And I'm sympathetic to both arguments, even though I agree the system as it is now doesn't work. There's got to be something has to change. But I'm sympathetic to that argument because let's go. If we go back to the black codes, at one point, for a lot of people don't realize this, and you can just look at the Supreme Court cases. At one point it was illegal in the South and again, 95% of black people lived in the South before the Great Migration, but we don't have to talk about that. When you look at the laws down there, if you were black and you were unemployed, you know what they did? They took you and sent you to jail and put you in the jails happened to be the former plantation, so you're working for free. If you were a woman and you were outside at a certain time in the day, they would arrest you and send you, and then you would go work as a maid in the house or something like that. And if you were even children, they would, and they found you, let's say, out of school that day, they would take you and lock you up. And they had children who would they would take black children and you could see the pictures. You just Google the pictures of black children at the penitentiaries, you doing the cotton gin and all that stuff. So we're talking about that's in the 50s and from the 40s and 50s. We're talking about that back in the black codes when you had and then some of the tests and stuff for that. So now you have that generation of people, right, who've gone through that. They move up south, and now you're telling the argument is they should be able to compete with people who didn't go through that. So I understand the whole thing of, okay, how long did it take a group of people or a society or that ethnic group to get out of that situation and to recover to the point where they can at least where they can compete on par with the other group? And that's what the Democrats are saying. The Democrats are saying, well, we want to make it just so they can be able to compete. And right now, based on all the metrics, they can't even compete. And then the other side is saying, well, they should compete, but it's not our fault that they can't compete, right? Because that happened 50 years ago. It's somebody else's fault. Why should we be penalized for them not being able to compete today for something that happened 50 years ago?
Or how about it's not working? You've had 50 years of this. Things haven't changed. Maybe it's not the best policy. Maybe try something else.
Well, things have changed, though. I disagree with that. Things have changed. I think today, if you're a black person living in America, you're living in the best time ever on the planet to be black in America. I don't think anybody can deny that, right? If you're a black person today, you're living tomorrow is going to be even better than yesterday, right? So
there are plenty who are denying it. I can show them to you.
Yeah, no, I know, but I think we're moving forward. But I think that's the issue now. And that's the issue in this particular case. Have we done enough to win? Where the excuse of the 50-year, that happening 50 years ago does it, or do those things that did happen, that we know happened, that's been well documented, are those things still affecting these people today?
Okay, there's a super chat on point, and it's a good question.
Mm-hmm.
There's no question that schools in black neighborhoods are subpar to the schools in white areas. What happens to those kids? I agree, it's unfair, but I have a question though. Why? Why is this? And I'm deliberately asking it. Is there something else going on here? Because money does get funneled, things do go in, and things don't seem to change. So is it a systemic issue or is it a cultural issue? And I kind of wonder if we have to look possibly culturally as well. But I mean, you guys are the big brains. You give me an answer. Why do we have the discrepancy consistently over and over and over? And when neighborhoods shift and populations shift, these problems tend to keep happening.
They follow.
Well,
yeah.
Where is the most what is it called? I always say this. Where's the most discriminatory school system in America? New York. New York City is the most discriminatory school system in America. And why? Why is that? Well, that was because they weren't forced to integrate. So we keep saying, why are all the bad schools in black neighborhoods? Well, in New York, the reason is pretty simple: is that the when you're a public servant here in New York, the longer you're there and the better you are, you get to choose where you go. So even sometimes the best black teachers and the best teachers in those they'll send those teachers to those schools initially.
Oh, somebody check this out.
I missed.
I just checked.
Do Boozy update?
It's not true.
I just checked. It's not true.
They love Boozy. They love Boozy, the Twitter. But what they found is that when teachers, after like 3 or 4 years, and they get all that hell from being in those neighborhoods, they didn't go and say, we're getting the hell out of here, we're going to the good neighborhoods. And those happen to be the white neighborhoods. And that's kind of how we had this kind of imbalance here in the city, where all the good teachers, obviously you don't want, nobody wants to work in a poor neighborhood where the parents don't really care and all that stuff. You want to move to the good. So that's what they kept finding. And they're trying to incentivize teachers in the schools to stay in those underserved schools. But it's just difficult because, after you've done 5 years there, you're like, I want to get out of here. I want to have I don't want to have a rough career, be in this place all that time. So it's tough. But even in New Jersey, one of the big issues they had was they said, okay, black schools were underfunded. So you know what they did? They threw a ton of money in the black schools, and the results became even worse. No one knows why this issue is like this, but hopefully, I think corruption. Now the cure is worse than the cold. And I think the cure of saying white, black, I'm going to choose the black just because black, and have those black students go in and fail and then say, we gave you a chance. That's not the answer. And I think Joe and I think everybody else on the panel is correct. There has to be a better way. And this is not the best way.
And my brother, and I see people in the chat talking about how it's expensive. It is expensive. That's why one of the voucher programs come up, but the school loves the money that they get from the taxes for that. So that's always the debate there. But there's an alternative to homeschooling as well that actually came up because of the pandemic. I don't know if you guys are familiar with the co-op systems that are available now, but
yeah,
like my brother, he puts his kids in a co-op homeschooling program. I think Nick does something similar too, doesn't he? Where they basically cycle through and they all have different parents that teach on one day, teach on another day, but it's a smaller community oriented way of teaching the children. This is the thing that I like. I like going back to communities begin in the household, right? That's the first community you get born into. Mm-hmm. You are raised and you're developed in that community. Then the next immediate community is, for example, the neighborhood, the kids' neighborhood, the household's there. You go over to the mama down the street and she cooks for you and does all that stuff. And you guys look out for each other. Then the community extends to the neighborhood. Then it extends to your soccer team. Then it extends to your high school and that community, your church, call it what you will. Where do you fix the problem? Because I can tell you where you don't fix it. And it's from an amalgamation of 9 million of these communities that the United States government as one whole has to come up with one policy to fix for all the unique children in all these different unique environments. You want to fix the kids. You want to teach the kids. You want to get down to the specifics of what these kids need. Start focusing on where your community starts. Where do you start fixing it?
Okay, and Peggy counters back, and I can totally see this. Black area schools are not getting money to fix their schools in Chicago, and that's why I think there's corruption. I mean, we know for a fact that there's a lot of money that is being funneled and moved to certain areas that somehow, like a school will get X amount of dollars, and somehow books aren't bought or things aren't improved.
And yet somehow throwing money at the prom historically has never worked.
I'm going to tell you,
has never worked.
I'm going to tell you one thing, and this is why now they're going to call me a MAGA Republican, whatever. It's the Democrats that are holding, I think, children back here in New York City. It's literally the Democrats who are holding Black children back from succeeding. And I'll tell you exactly why I'm saying that and the reason why I'm saying that. Here in New York City, we have the charter school system. We have something called Success Academy. And when they started, they said, well, we can do something. We're going to go to the worst neighborhoods, the worst Black neighborhoods, open charter schools in those neighborhoods, and we're not going to use, like say for instance, for a public school student, I'm making this number up. For a public school student, it's like $10,000 a year. They said we'll do it at 2/3 of that. So I mean, at 3/4 of that. So we only take $7,000 a year instead of $10,000 and educate your student. So they did that. They went into the poorest neighborhoods, and they opened up shop. In about 2 years, they are the highest performing schools in New York State. I'm not even talking about in the city, in New York State. And these aren't white students. These are Black students and underprivileged students, right? So they're doing it with less money, and they're getting better results. You can even look at it now, where for instance, the school my daughter's in, they had like a 99% already passes the state exam, and literally the school next door is 30%. So what happens is mayors like Bloomberg, Obama, Al Sharpton are like, hey, we need to stop this public school thing because obviously it's not treating kids. We need to have these charter schools come in and take over because they're actually, the students who are going there are not only learning, but they're excelling. They're competing. This is the thing that we've been looking for, right? How to make Black children compete with white children. Here it is. Matter of fact, they're not competing. They're excelling at competing. So but you know what the Democratic mayor of the city did? He said no and doubled down because you know what? He wanted the unions.
Teachers unions got involved.
And they limited. So now get this: you have the best schools in the city who are now limited to expand because they want to literally force Black students into failing schools to keep these people paid. That's the system that we live in under New York. And then whenever you say that, hey, this is wrong, we need to change this, the problem is, oh, well, you know what? You only want to pay these white people in these schools to take our money from public schools. And that's the reason why public schools aren't that great, because they're taking money and giving it to these charter schools and taking only the good Black children in the neighborhood and putting them in these and trying to make us all look.
I was going to say all the politicians' kids in the neighborhood, I bet, are in the charter school if they're living in the neighborhood.
Yes. Yes,
yeah, I would poll whose kids are going to that charter school. Half these people are voting against it, probably.
And
Sidwell again, friends.
This is everybody. This is Obama's for charter schools. Al Sharpton's for charter schools. Like the whole everybody who knows is for charter schools, but the people who are not are the politicians who need the votes from that union.
Yeah.
Unions are. I mean, it's the same way Republicans are accused of being beholden to big business. Democrats are beholden to unions. These go way, way, way back.
But just imagine if we did fix that system where now you don't have that problem, because again, the kids who are going to the charter schools are getting a way better education than kids who are going to public schools. Mm-hmm. But then the Democrats send them to these bad public schools, then send them to these bad high schools. And then when they go to college, they say, okay, well, we want to give you a leg up because it's racism. We're going to give you a leg up and just put you into a professional school. And when you fail out, it's not your fault. It's a fault for people 50 years ago. And I think that's the issue now. It's if they went to schools where they can compete at and got those resources to be able to study, to be able to learn, then when they get to college and they get to these professional schools, you don't have this problem. But right now, the problem is educating children at the grade school level and giving them the right shot versus this, let's let them fail out to support the teachers union and then give them an extra chance when they get to law school. At that time, it's too late. It's too late.
Have you considered the fact that maybe there is a part of this that if the problems get solved, activists have no reason to exist?
I was just going to say that another factor here is the politicians who keep running off of a platform of elect me, I can fix it. Elect me, I can fix it. And as soon as the problem is fixed, then if that's their main issue,
we don't need you anymore.
Elected on, yeah, right. Then it's like, oh, okay, we can elect someone else. So the problem continues to persist. Then they have a purpose while as an elected official.
Yeah. I mean, Jesse Jackson, and what would he? I mean, and different people. I mean, they're literally people. Their whole career is complaining about systems, and if things are actually improved, or what are they going to complain about? What are they going to do? There's no more reason for them.
There's an old saying, which is, if you give a man a fish, he'll need another fish tomorrow.
Yes.
Yeah. Speaking of people who have no purpose, I missed the Boozy update.
Okay.
Oh, well, no, he hired one of the best law firms in the country. I forgot what's the name of it?
Ballard Spahr.
Ballard Spahr.
Yeah, but they're also
Amber Heard's attorney.
Amber Heard, yeah. We read the first review. The first review, it seemed like it was from a defendant who just hate, who they beat and they wanted to just shame them. It
definitely read like someone who wasn't actually a former client.
It was a bullshit review. But they're obviously a top-notch firm. So we'll see. Now we got an interesting fight on our hands.
Yeah. Okay. But so they accepted service on their client's behalf?
No, they haven't done that. No.
We don't know yet.
That's a sweet assumption to make.
That's the normal thing to do. I will accept service on my client's behalf.
They don't have
an answer.
Well, to be fair, we don't know if Ron has called them yet.
Mm-hmm.
We just know that the announcement has been made that they are representing him, according to Boozy. If
and
Boozy
by the way,
is to be believed.
No, we got the notification too.
You did? Okay.
Yeah. Mm-hmm.
Just so the audience can understand that when you're engaging in litigation, and when attorneys are engaging in litigation, you can be a schmuck and basically say, I'm not giving in. Hey, there he is. And say, I'm not giving in here. I'm not giving in here. I'm not giving in here. I'm going to make life as miserable for you as possible. And the upshot of that is you get that back. You end up getting back in return, and you basically spend the entire time being as hostile as possible over ticky-tacky, relatively petty stuff, just to sort of almost seemingly for the purpose of making your adversary's life as miserable as possible. So they try to make your life as miserable as possible, which is why in most circumstances, when you're dealing with, well-established professional firms, there are certain basic courtesies, not that they're giving anything away that would disadvantage their clients, but not making people crazy in a petty way for the sake of making them crazy, just to make life more difficult for them when it's not really advancing the causes on behalf of their clients.
For example, not accepting service.
Right.
Ron, why are they not accepting service? Are they objecting to personal jurisdiction?
Well, they just got hired. They may accept service.
they may accept service. We don't know.
They may accept service.
Ron, check your DMs, please. On Twitter.
I'm sure there's an invite in there.
Yeah, I mean, and then another factor of like what Joe was just talking about is also like, I mean, if you're in a particular niche area of law, you may run into these other lawyers across the aisle again and then have to litigate against them again. So do you really want these other people like being assholes to you on another case and then another case and then another case? Like it's not worth it when you have an ongoing professional relationship.
Yeah,
I mean, I don't know. Some people find it.
That's true. That's true. I have one guy I've been litigating against across 4 different cases and I've been literally engaged in litigation with him in one case after another for 15 years.
Oof.
This guy,
like,
other side of the
it's like jail winger against all of the people in the Manson cases.
Yeah, it's like some people were DMing like, "Oh, are you mad about these people are evil?" Like these people are. The law firm has nothing to do with Boozy. There's somebody who's hired. Matter of fact, if I was just a lawyer out there, who's doing a job, right? They're gonna write some. They're gonna, just like Ron wrote the crazy stuff for us. They're gonna write crazy stuff for Boozy because that's their job to do it. They're not bad people. They're just they're being paid to do a job, and I expect them to do it professionally and to the best of their ability. That's what I do.
Lest we forget, the David Brooks case is a prime example of why it's good to have competent counsel across the aisle, because you don't want to be like just absolutely going insane because of who you have to talk to every day.
Here's what this guarantees. This guarantees that you're going to have fully vetted arguments on First Amendment principles. Mm-hmm. Now you have good. You're going to get the discussion out in the public. You're going to be able to have the debate. That's going to be an informed debate on both sides. Honestly, this is probably the best outcome, that you have someone that can actually come to the table and make these arguments. Both sides. Sorry, Ron, you'll do fine. I saw your complaint, read the language, loved it. It was snarky.
You definitely got the snark in early.
Did I not say Daryl Brooks? Did I say David Brooks?
I think you said David Brooks. Yeah,
you did.
Sorry,
Daryl.
I meant to say Daryl.
We know what you're talking about, though.
I do this all the time, and people get mad at me.
Ron.
All right.
Good to see you.
Okay, so we have the expert here, and we can ask for guidance. What is going on? What are you thinking?
There we go. He's muted.
There we go. There we go. You should start every show like this.
Boozy got you. Boozy got Rod.
No.
Nope. You got to go to audio.
Gotta go to audio.
Go to settings. Audio.
And today's boomer moment is provided by. No.
He's like Ariel when she shows up on the land.
The bane of so many people's Twitter existence, and he can't figure out a microphone, and he's listening to me talk about it.
Oh, I'm hearing something.
Oh, there it is.
Yeah.
I heard it. We heard it.
Pilot to co-pilot.
Yeah, we got you.
We should have kept it going. We should have pretended like we couldn't hear him.
Oh, that would be funny.
I've done that.
You guys. Yeah, so as you understand, what I need to do now is to explain all my strategies that I intend to employ, because a paralegal might have suggested that I don't really know what I'm doing. So this would be a great place to do it.
This is where you win the court case, right here.
I thought you did it on Twitter.
Make your best arguments.
I thought you did it on Twitter. You did it on YouTube?
I might not have satisfied Akiva Shapiro sufficiently.
Akiva Cohen.
Okay, sorry, Akiva Cohen. Yeah, Shapiro is a Cohen name, but he's not Shapiro. Akiva Shapiro was actually a real person who was a lawyer, who's a very nice young man and does First Amendment work, actually. Anyway.
As opposed to Akiva Cohen, who doesn't know it, but just talks about it.
He doesn't. So. He's a copyright lawyer who probably feeds his family. What do I? But I mean, all right. So we got an email from Ballard Spahr, which is a very well-known and well-respected Philadelphia law firm, which is like a lot of Philadelphia law firms expanded to being a sort of they would like to think of themselves as a national law firm, and everyone else still thinks of them as a Philadelphia law firm. And they're, I have a lot of colleagues that I've been friendly with there over the years. We already opposite Ballard Spahr in Gavin McInnes versus SPLC. They represent SPLC. So they know what they're doing. Right? This is a law firm that knows what it's doing. But the real thing, and I think a few of you alluded to this, is that once you have a grown-up on the other side, it gets a lot easier to manage things.
Yeah.
And you don't have, I mean, what I really hope will happen is that, I mean, someone passed on to me a tweet from the defendant in this case, who said that he's proud to announce that he has retained Ballard Spahr to represent him in the lawsuit that Nate Brody brought again, that Ron Coleman brought on behalf of Nate Brody. Why is Ron Coleman part of that story? Okay, answer: because Ron Coleman is a notorious right-wing Nazi Orthodox Jew. So I get it.
What a sentence!
I get
Yeah, that's a hell of a sentence.
Welcome to my world, Alita. But what I would hope is that that's a discussion that we can have with the Ballard Spahr guys and say, what if we take the personalities of the lawyers out of this? I mean, I don't expect my clients to have anything to say about your firm or your lawyers, and it would be a good idea if you could encourage that. He doesn't have to, or he could say, "Listen, I had to talk, but my client's going to do whatever he wants." But at least if he has to talk, I think it would. Yeah, I will tell you something else. Among the categories of screenshots of tweets that was in my little basket while we were preparing the lawsuit was tweets about me, Ron Coleman, because it's a really bad look. It's a really bad look, and obviously the complaint is your opening shot, and you want to convince the judge who's. There are a lot of people ask questions, and this is something LawTubers love to do. What does this have to do with such and such claim? What is this? Now, it is true that the federal rules of civil procedure, just like the rules of actually, this is not. I don't follow the federal case; it's now been removed.
Right. It's Jersey.
We're now in federal court. But that all modern pleadings are supposed to be a short and simple statement of the claims. But it's also true that it is always useful to include what we call color, give some background, especially when there's going to be a motion to dismiss, and all the more so when there's going to be a motion to dismiss based on actual malice. Well, once you get into actual malice, it starts becoming very useful to let the judge know who the person you're alleging has been doing the defaming, what he's all about, because if someone said, that the people in this panel, defamed somebody with actual malice, well, I know that these are all respectable, responsible lawyers. I would be really surprised to find out that they were saying unhinged, because actual malice is really a high standard, right? It has to be a knowing disregard for the truth. Knowing it has to be either willful, you have to know it's the truth, and you only disregard it, or you don't even make, it's basically you knew or should have known that the allegations are false. So the more likely it is that somebody looks like the kind of person who could be plausibly alleged to have done something like defame a person to the actual malice standard, then the more relevant that's going to be. A lot of talking there. I'm sorry for that long.
No, that was
good.
Several tweets.
You're explaining, but here's the thing that's important is a lot of people looked at your complaint and looked at the extraneous stuff and had questions as to why it was so long and so extensive and included so many details which seem extraneous or excessive or unnecessary, and you're basically saying no, I've been doing this for years. I've been fighting these motions to dismiss because there is going to be a motion to dismiss. There's always a motion to dismiss, and I know that I have a better chance of succeeding if I draft the complaint this way by including background that gives the judge a reason to think that the person intentionally was lying, rather than slipping into the facts. And that would make more likely I'll win on the motion to dismiss.
Right. No, right. In other words, remember that a pleading is not a place for evidence as such. It's a place for allegations. But plausibility being a factor that a court considers when reckoning whether allegation. In other words, there was a little bit of a sea change, right, after the Supreme Court said, no, it's not enough to merely allege. You have to allege a believable story. And that has trickled down to the state courts as well. Of course, now again, I'm in federal court, so the plausibility standard is going to be the one that's going to be applied. And yes, you're not convincing the judge that it happened. You're convincing the judge that if you let me get my discovery and try my case, a jury is a pretty good shot I'm going to find proof that it happened, or that at least there'll be sufficient for a jury to decide whether it happened.
It's an interesting question. I don't know if we can go into it, but if you're Boozy's lawyer, what would you advise him to do?
Shut up.
Stop tweeting.
Settle, and get pay Nate his money.
Accept service.
Stop talking to anyone.
Yes.
Shut up. Close your Twitter for a solid 3 months. Get off the interwebs. Every single thing you have done, stop doing it.
Yeah, by the way, this is what a serious answer along those lines is. He just went off on a thing saying that he's going to close his Twitter account if the Senate doesn't.
Oh, I know. Please, every screenshot.
Hold spots. Yeah, when that does not happen, if he imagine how much more respect he would get
if he did
for at least a couple of months. He sort of inactivated his Twitter account after they don't pick up 2 seats. That people are like, wow, this guy really stuck by his word. He really, and that's what I would suggest as his attorney. You'll garner so much respect that you're a man of your word if you actually inactivate your Twitter account. I don't know if he has to close it all together because he has all those subs, but imagine how much respect you would get, and you look like a man of your word, and you also won't be tempted to say something that's going to make it much harder for me to defend you. So that's really, I mean, maybe that's too much advice I'm giving him, but I'm telling you right now that's what I would suggest.
But Joe, you would either then be in a situation where the client would discharge you, or would be affirmatively not listen to your advice, and there would be, because that's utterly unrealistic. The guy lives on the internet; that's his entire existence. And also, let's remember something here. This lawsuit is a Twitter/social. This is a social media lawsuit. Mm-hmm. It's largely because it started out with what Nate said about bot Sentinel, getting under this guy's, or what all the LawTubers said about.
Well, Rob, and before that, Ian, and
it was Ian, then Rick.
Oh yeah, Joe at one point too. He talked about Joe living in his mom's basement or something.
Personal with Joe. Then he called me a criminal on Twitter. And
because
that were false.
Right. Nate actually hadn't said that much. It was on this stream. Rob went after his bankruptcy, and so he went into Rob, put out claims about Rob that were specious at best, and then he said, "Now on to Nate." Found an old interview.
I remember looking for the
there
first.
There was some other Roberto that he pulled up as Rob.
Yeah, he pulled up Roberto Morton. Like there's another person in freaking Virginia, and he starts throwing up his traffic stuff. I'm like, dude, come on. I know I speed, but not like that.
What were you saying, Ron?
What was I saying?
You were looking for the first tweet.
Oh no, I was looking for that first tweet and and now on to Nate. Like, what was the context? So he was going down the list. I got that, figured that out. But my point is, so then Nate gets into this, and he's and because Nate, look, anyone like you guys who have such profound investments in YouTube and in your YouTube channels, the ability of one man using an algorithm that is the exhibit A for the proposition of garbage in, garbage out, because I don't care what algorithm you run and what machine learning and artificial intelligence you're operating with. If you start out with, okay, so first let's take 5,000 normal or 2,500 normal accounts. What's your metric for normal accounts? Mm-hmm. Well, the ones that I think are normal, is that how it really works? All right. So the point is that person is a threat to you and your livelihoods, because he's already demonstrated, whether it was for the most idealistic reasons, the way he sees it, or whether he was paid to do so, he got somebody knocked off YouTube and went on to brag about it. And the more he brags about it, the more people who are sympathetic to him support him, and the more the more media, the more corporate media buys into what he's saying, and that's why we are what we are. So the point is, this fight is largely a social media fight, and I wouldn't just as I wouldn't recommend that Nate get off the internet, because all Boozy has is the internet, so he's not going to go anywhere.
Yeah.
By the way, somebody in the chat reminding me, they asked on Twitter, Ron, Nate, everybody, any updates on Boozy's bankruptcy case?
Oh, the only, because again, the investigator contacted me. I've spoke to the person about 3 times, sent them the stuff, confirmed that they got it, and they said particularly they won't tell you if they're doing anything with it or not. It'll just happen.
So like the FBI in that sense, that they never they're like,
they
thank
never
you very much,
confirm
and
or
they
deny.
never say that they're okay.
But the thing is that I don't think they would have called back 2 times if something, if they didn't see something. But again, they may have looked at it and said nothing.
Did he complete the bankruptcy? Is he
no
No,
he did
it was
just
discharge.
Yeah, it was essentially as he tweeted out, just as a tactic to help delay the eviction. So I'm thinking they just filed it to, again, allegedly just filed it to avoid the eviction.
Okay, now Ron, with him getting a law firm, will that help with service?
We're going to work out service. I mean, they already, one thing a federal judge doesn't want to hear about is to have a major corporate firm like Ballard Spahr show up in court and say, well, we removed this case to court, but our client hasn't been served. Now,
then the judge turns to you and says, have you tried to communicate with them to see if they'll accept service? And then you say, yes, Your Honor, many times.
You should. A lot of people don't realize, though, that removal, under the rules and the cases interpreting the rules, removal, the deadline for removal actually begins the clock begins to tick on removal for when the defendant learns of the lawsuit. You don't have to wait to be served, which also places an affirmative obligation on the defendant, if he wants to remove promptly, because you can see the potential for playing games, like by getting yourself a long extension of time to answer by evading service. Meanwhile, you've already moved the case into federal court, whatever. That's not going to be a problem anymore. What inevitably happens, and I have not had this conversation with Ballard Spahr, so I'm not speaking out of school, but what inevitably happens is the other guy says, okay, we're going to be doing a honking big motion. I mean, I already know their papers, right? The law's not that different in Alabama. Can you give us more than the 20 days that are provided under the federal rules of civil procedure to answer? Otherwise, respond. And of course, I'll say yes, especially because in the District of New Jersey, there is a provision for what's called a clerk's extension. They automatically can get themselves more time. So I'm not going to say no on that. What they're going to have to do for is kind of give them. What's going to happen is that I'm not going to want to give them much more than a total of 30 days. And they're going to want more than 30 days because they're a big law firm. Guys, the real question you should be asking is how is he paying for Ballard Spahr?
Yeah, that's a very
the same firm as Amber Heard. I don't know. Maybe Maybe there's an arrangement. I don't know. It is a coincidence. I'm not a lawyer. I'm just saying, interesting.
And it's the same firm as Southern Poverty Law Center.
Mm-hmm. Hey, how about Media Matters? Are they tied up with them at all?
I don't know. They've steered clear to me pretty much.
Okay. Oh, Ari's saying hello.
Ari.
Ari.
Hey, Ari. Oh, thank you. Our client, the great Ari.
I thought she was your client. You're representing her against Taylor Renz, right?
Yes. I mean, that's actually that is a Harmeet. Harmeet is running with that, but Ari is a friend of mine from my podcast, and of course, any client of our firm is our friend for life.
Yes, I did a full interview with Ariadna on this channel. If anyone wants to check it out, laying out the entire Taylor Lorenz case at that point. And
have they moved to dismiss that new amended complaint?
I don't know.
Are they going to move to dismiss that one?
Ron, you're not handling that directly, are you?
I'm not, but if it's a defamation claim, which it is, they will be moving to dismiss it. I mean, that's what you do. No one, if it's somebody actually asked while we were talking about something else in the comments. Hey, why? What was it? Something about discovery. Oh, why would he be defending? If he defends, then he has to give up discovery. No, the idea is to get the best possible lawyers you can to get the case dismissed, because there is still such a strong inclination. Although the last New Jersey defamation case I handled, there was a motion to dismiss, and it was denied because we had really, it involved a politician here in northern New Jersey. And listen, we don't file it if we don't think we've got a pretty good shot at, getting past that motion.
What about the Jason Goodman case, which seems to be kind of hanging out there?
I don't know what's going on there. I have to admit that it's curious that Joe, you had actually dug that up, weren't you? Wasn't that
when I looked at Jason Goodman's claims, I had a lot of questions.
Oh, Jason, the claims are crap. But where his lawsuit is procedurally though, he attempted to serve. They did the three things. Then they did the nail and mail. The judge. Then they went to but then Boozy never. He never showed up. Never answered. The judge said, "Well, hey, listen. I think there was like he was suing two people, so there was like a status conference in which the judge said, hey, it doesn't. He wasn't personally served, so we have to kind of deal with whether this was enough. The nail and mail was enough to serve him. But as of right now, Goodman never filed the motion for default, which it seems like the court seems to be waiting for. We filed the motion for default judgment, and then they can go into whether we served properly or not. So it's just kind of just sitting there with no motion filed, and everybody's just waiting. So, but as of right now, he hasn't. Boozy has not responded to that lawsuit, and it's just sitting there, pretty much waiting for either him to file a motion for default judgment or for him to close the case.
How does that affect your suit, or does it matter, or is it irrelevant?
If a default judgment were entered, all the allegations of the complaint would be deemed admitted. So those could be useful in a sort of technical sense. But as Nate pointed out, they're not all that powerful. And at the end of the day, you still have to convince the fact finder of your case. And a default is a default. And again, for purposes of that party, the admissions are admissions. But if those admissions don't really, if one of the admissions in that case had been that the defendant runs a scam called Bot Sentinel, and it does like stuff that really dealt with the allegations here, or that were really parallel to the allegations here, then that would be, again, technically helpful, but
helpful de jure, not de facto.
Ooh, de facto.
Go ahead,
Joe. Somebody said, could de jure also be seen as per se?
No, not really.
Really? Okay.
I'll have the potatoes.
Okay, so next question, and I know Nate and I have talked about on the side. He's always wanted to set expectations. I'm guessing that we're looking at like another year of this, right? That this is not, we're not going to be hearing back in 3 weeks that it's all over.
Well, like I said, assuming, let's just say for argument's sake that we agreed that they would file their motion to dismiss in the first week of December, just for, So then we would want, since we would be giving them a month to answer, we would presumably want more than the usual amount of time provided for a response in the federal rules. What happens then? That gets us into Christmas, which now that's not a problem for me. But they might not want to have to write their reply brief during during the period of Christmas to New Year's.
Well, let's slow this down. I think on the timing, you might be not addressing this properly, because if they're first getting it now and their time for 20 days starts now and they ask for 30 days, we'll already be near Christmas when you're first getting it. When they file the motion, it'll be like a week or two before Christmas. So if you
no, 30 days. In other words, their motion would be due first week of December.
Oh, that's what you're saying.
But then let's say for argument's sake, I want 3 weeks to respond. Boom, there I am, middle of Christmas.
Right.
So then, what we're now, the fact is there isn't like a rule. There's no law against working on the last week of December, except in lawyers just don't do it.
De facto.
So the motion can be expected to be fully submitted in January. Let's put it that way. Then what happens? Then it depends on the judge. It's not going to, what happened to me in Alabama, where a judge has sat on a motion for 3 years.
Ooh.
3 years. That's unusual. And that's something else that's going on that I wouldn't want to say directly. But that's not going to happen in the District of New Jersey, and it's not going to happen with this case. So once the motions are in, you're not going to hear about it for a while, because it'll be on the fact is, judges can, some judges move faster than others. District of New Jersey had a lot of vacancies until the last year. There must have been, as far as I understand, all filled. So they're still playing catch up. And there's a lot of multi-district litigation in the District of New Jersey because of a lot of pharma companies are located here. So, it would be...
You'll be breaking matzah, and everyone else will do the Easter egg hunts before you get a decision.
It's entirely possible. Yeah. It's entirely possible.
Okay. So, I just want to set expectations, because I do think that, I'm super excited about it because I love the content and everything, and a lot of other people are. And it's like it doesn't happen, I understand, in a week or 2 weeks or whatever else. And we just kind of want to put out the message that
that's right.
Be patient. These things, it's like a process, I guess. It just takes time.
From an outside perspective, it feels like it takes a long time, but when you're the litigator working on the case, there's a lot that goes on behind the scenes, and it can feel like it's moving actually very quickly. But yeah, from the outside, patience.
Mm-hmm. All right. Well, on that note, I know that we had a tight schedule. Nate has to go on to other things. Where can people find you, Nate?
Nate the Lawyer, locals.com. NateTheLawyer.locals.com. I'm taking my cue from Barnes.
All right. Rob.
Law and Lumber. See you guys tonight. Friday Night Frenzy is happening 8 p.m. So I'm going to put the link for that up. You'll see it in a minute or two.
All right. Ron, you're on YouTube and have a podcast too, right?
Right. A Coleman podcast. You just Google Ron Coleman podcast. Lawyer. Put in lawyer, you're going to get a very large, non-Jewish looking man for a result.
Okay.
And but if you really want to know where to find me, you find me on YouTube at Ron Coleman.
Awesome.
I'm sorry, you find me on Twitter at Ron Coleman. But I got the channel too.
I'm on YouTube as Good Lawgic. I am on Rumble as Good Lawgic as one word. And I am on Locals at goodlogic.locals.com. And also next week is going to be we're going to have election day. I plan on basically doing a very extended stream. It's going to be like 8 hours of coverage where I'm going to basically be trying to cover results as they come in, probably starting around 7-8 o'clock at night. So yeah, should be a fun time. I plan on cross streaming. I was talking yesterday with Legal Mindset about cross streaming with him because he's going to be doing a similar thing on Rumble.
Cool.
So there we go.
Awesome. Alina.
You can find me at LegalBytes on YouTube and all the other social media platforms as well. Next thing I'm going to be doing is on Mondays, I have started to go back in time and live stream some classic trials. So lately I have been on Mondays, I have been live streaming the Eric and Lyle Menendez trial. We started getting into testimony on Monday. So it's very, very interesting already.
Cool. Wow. Now with me,
Monday at noon East Coast time.
Oh, I'm sorry. And with me today at 5:30 on America's Untold Stories, we have Viva and Barnes joining us for Freeform Friday. Last show before the election coming up. So anybody who's ever seen that stream, The election will probably be part of it, along with solving the world's crises, along with terms you've never heard of that involve weird things with Hollywood people, involving conspiracies from the side, and anything else that comes along. And it'll be Mark and Barnes going at each other, and David and I will be like two cats looking at a laser pointer on the wall, trying to figure out what's happening. So definitely check it out, and I hope to see you then. So thank you very much.
So long, guys.